We are going to go ahead and get started with tonight's presentation, talking about common bylaw violations and how to handle them. So if you have not met me before, or if I have not met you before, my name is Kayleigh Long. I am a senior attorney here with Hirzel Law, and I focus on association litigation and enforcement. And so bylaw violations are what I deal with primarily day in and day out, and helping associations work through those. And so today I've really kind of tailored the presentation to focus on the common bylaw violations that we see, including some that I'm seeing more of over the past year that are kind of on the rise, or are ones that I didn't necessarily see before, but am starting to see now. And so we'll make sure to discuss those. For today's presentation, feel free, if you would like to participate, I'm going to be asking questions. Give me your thoughts, your answers in the chat box, or if you would like to unmute yourself and provide your feedback, we would be happy to hear it. But in the meantime, if you're not speaking up, just make sure to keep yourself on mute so everybody can hear. And of course, there will be time for questions at the end. So I'm going to review for you just a brief summary of the topics that we're going to be talking about today, some of the heavy hitters. So first off, of course, pets, short-term rentals and leasing, marijuana and smoking, parking, towing, hoarding, unauthorized modifications, alterations, security cameras and ring doorbells, and signs and lawn ornaments. So that is a brief overview of what we're going to be covering today. There is a lot of ground, so buckle in, and we will start with one of the most frequent heavy hitters, which is pets. And today we're specifically going to focus on size and weight restrictions and emotional support animals. So first up, we have here David, who lives in a condominium that prohibits pets that are over 50 pounds and its rules and regulations, but he decides that that rule is ridiculous. And so he buys a puppy that initially weighs 15 pounds. And over time, though, of course, that dog grows to be 80 pounds. And the association tells David that he's going to have to get rid of his dog because it's too big now. And so the question is, first of all, does it matter that when David bought the dog, it was only 15 pounds? Does he get out of a possible violation here based off of that fact? See if anybody has any thoughts, or if anyone would like to unmute themselves and participate. So go ahead.
I say it doesn't matter that it was 15 pounds when he moved in or whatever, based on breed and generally breed, you can tell how big the dog is going to become.
Yes. So, and I see too, somebody else said, no, it doesn't matter. When agrees here with, I believe this is Tammy from Villages of Oscoda. And so that's correct. It does not matter the fact that when David initially bought the dog, it was only 15 pounds. So that's not necessarily at issue here. However, there's still the broader question of, can David keep his dog? Anyone have any thoughts on that? All right, well, based off of what, and Jordan responded, no, unfortunately, he won't be allowed to. And that is probably correct, not only because of the weight issue, or I'm sorry, actually, I have to rewind that back. Under the weight issue, possibly, yes, he would have to get rid of the dog. However, as you can see here, I have a little court case citation to a Court of Appeals opinion from 1989, unpublished, but the tricky issue here is that the weight limit was provided in the rules and regulations. It was not within the condominium bylaws. And within this particular case, the Court of Appeals said, listen, putting a weight restriction in your rules and regulations instead of within the recorded bylaws was unreasonable. And so putting that weight restriction only in your rules and regulations instead of having it in your bylaws, that was not a permissible move on their part. And so actually in this case, David does get to keep his dog because of that little nuance. And so the question, of course, becomes, what if that size restriction was in the condominium bylaws? And that is something that the court still has not unfortunately addressed yet. So while we do have a Court of Appeals opinion saying the size and weight restriction, the rules and regulations, it's not going to fly, it needs to be in your bylaws, we haven't seen yet a Court of Appeals say that if you have a size and weight restriction in your bylaws, then that therefore makes it reasonable and enforceable. So probably a stronger argument there that David's going to have to get rid of his dog if the size restriction was in the condominium bylaws. But just a note that the legal landscape on that is still a little murky, and there may still be an argument there that the size restriction is unreasonable. And then transitioning into our discussion on the emotional support animals, of course, the question is let's just assume the size and weight restriction is in the bylaws and it's valid and it's enforceable. Does that change if David's dog is his emotional support animal? Does anyone have any thoughts on that? Of whether or not he's going to be able to keep a dog that violates a size and weight restriction that's in the condominium bylaws if the dog is his emotional support animal? See if anybody chimes up. So it would matter. So under the Fair Housing Act, okay, so Jordan's responding to basically everything tonight. She says that she probably will be able to keep that. And Jordan, I think you're right on that. So under the Fair Housing Act, service animals and emotional support animals are not going to be subject to size and weight restrictions. So if it is his emotional support animal and there is a valid size and weight restriction for your particular community, that emotional support animal is still going to be able to stay because of the person's need for the emotional support animal. And speaking of, we will go ahead and move on to emotional support animals more broadly. So Tanya subdivision has a deed restriction that prohibits all pets, and she suffers from severe anxiety and depression and has been prescribed a dog for emotional support. So she requests a reasonable accommodation to keep the dog, but the association denies her request because the dog violates the deed's restrictions against all pets. So they decide to file a lawsuit to have Tanya remove her dog from the subdivision. And so the first question that we have here is Tanya entitled to a reasonable accommodation to keep her dog? See if anybody has any thoughts on that. Some people answering yes. So in this case, I think the association might need a little bit more information, but it sounds like Tanya is probably going to be entitled to a reasonable accommodation. So under the Fair Housing Act, a homeowner, whether they live in a subdivision or a condominium, when they request a reasonable accommodation based on a disability, which is what Tanya did here, they need to provide, sufficiently reliable information to demonstrate that they have a disability as defined by the Fair Housing Act, what their requested accommodation is, and the connection between their disability and the needed accommodation. So in this case, we see here that Tanya suffers from severe anxiety and depression. Those both would qualify as disabilities under the Fair Housing Act. She's specifically requesting a dog as a reasonable accommodation. And so in this case, the association might want to ask for a little bit more information from Tanya as to the connection between her severe anxiety and depression and the emotional support, specifically how it helps her live and enjoy her home just as a normal or just as any other person would be able to. But here it does sound like she's going to be entitled to that reasonable accommodation. So of course, will she have to remove her dog? And the answer here is going to be likely not, because again, she's likely going to qualify for a reasonable accommodation. And similar to our last question, what if her dog was a breed prohibited in the deed restrictions? So a dog like a Rottweiler or some other pit bull, something of that sort. Is she going to be entitled to keep that particular dog as her emotional support animal? See if anybody has any thoughts on that. There is a good question out there while I wait to see, what if it's an unusual pet like an elephant? And so we'll talk about it briefly on the next slide, but the Fair Housing Act does have guidance on what happens when you have co-owners who are, or homeowners in general, who are requesting reasonable accommodations for not commonly kept in the household pets, such as chickens, things of that sort. So, you know, anything that kind of falls outside of your cat, your dog, you know, small little reptiles, hamster, gerbil, things of that sort. Anything that counts as an unusual or unique animal, the Fair Housing Act allows you to ask more specific questions of that homeowner. And so to specifically ask them, you know, what is it, what type of support does this animal provide, whether this animal in general or this particular animal provides you. And so you do get to question that request a little bit more. And so here, I'm going back to the question of breed restrictions. We have here two answers that even if Tanya's dog is a restricted breed, it's probably still going to be able to stay as an emotional support animal, and that is also correct. So Fair Housing Act also says, in addition to size and weight restrictions, breed restrictions do not apply to emotional support animals. And so one last final twist here. What if her dog had a history of biting strangers? Is she going to be able to keep that dog now as her emotional support animal? And so while I wait to see some people's thoughts on that and the issue of history of biting strangers, there's a question of what qualifies a dog to be an emotional support animal? Do they have to have any specific training? The answer is no, they do not need to have any specific training. If it's a service animal, so a service animal that is there to help the visually impaired and things of that sort, there might be some requirements for special training, but an emotional support animal does not need any particular training. And typically all that the homeowner is going to have to show is that this particular animal provides them with some sort of emotional support that helps alleviate whatever their disability is, and allows them to, enjoy their house. So the HUD has said in some instances, the animal can simply just provide the person with a reason to live, a reason to get up out of the house, take care of themselves and things of that sort. And so typically you'll see that evidence in a doctor's note. You won't necessarily have to, or the homeowner doesn't necessarily have to prove that they are trained in any particular way. So there has been feedback on the history of biting strangers. And here the Fair Housing Act says that you are not, and you do not have to grant an accommodation request if there is, going to cause direct harm, or there's, some sort of threat to the safety of others. And so in this instance, because the dog does have a history of biting strangers, you would be able, or the association would be able to deny the request for that reason. I just want to briefly note, though, that it has to be based off of that animal's specific conduct, and it cannot be based off of a stereotype of the breed. So if she had a pit bull, but the pit bull had no history of aggressive or dangerous conduct, you wouldn't be able to deny her request simply saying pit bulls are dangerous. If you're going to deny a request based off of, potential dangers and threats to this safety, you're going to have to show specific instances of that particular, that animal's particular dangerous conduct. All right, so let me see, move on to the next one. I'm just gonna check here. Gonna check waiting room and see if there's anyone. Okay. I'm gonna admit some people at the end. All right, so, oh, and as I said, here are the emotional support animals. This is some really good guidance from HUD. I will say it is not going to be your end all be all, and it's not going to give you every answer under the sun on emotional support animals and service animals, but it does provide a good step-by-step analysis of when you have a request for a service animal, what sort of questions can you ask? And when you have when you have a request for an emotional support animal, what are some of the additional questions that you can ask as well? And what are the considerations that you can take into mind when deciding whether or not to grant the request? So I strongly recommend having a copy of that on hand, and at least as an initial step when you get a request, reviewing that. So next up, another big topic that we have, especially for our communities that are in the vacation rental areas, are short-term rentals and leasing problems. So we're going to discuss short-term rentals, lease compliance under the Michigan Condominium Act, and just some general guidance on how to address high number of rentals in your community if that's something that you are wanting to limit. So, of course, as we all know, there are a lot of short-term rental websites and platforms out there. Many times homeowners will post on multiple websites, and it's hard to stay on top of all of them, but they are there, and it's something that unfortunately many associations have to address. So in the context of short-term rentals, we have here Jack and Diane, who own a lot in a subdivision that is restricted to residential use and prohibits commercial activities on their lots. And they use their lot for short-term rentals. And the association sends them a violation notice and threatens to file litigation if they continue with their short-term rentals. Jack and Diane argue, however, that they can continue short-term renting because the restrictions do not expressly prohibit short-term rentals. And so the question here is, who wins under this scenario? All right, we have quick answer here, association. So in this case, it is likely that the association will prevail. It is a very factually intensive issue, and so every case is reviewed based off of their particular facts, but there is some general guidance out there from the Michigan courts on this issue. So first of all, we have a residential and a commercial use restriction, and deed restrictions can limit residential and commercial uses of property. And the Michigan courts do note that a commercial restriction tends to prohibit more activity than a restrictive covenant that only limits property to residential use. So if you're an association that doesn't have language that specifically addresses short-term rentals, but if you have both a residential and a commercial use restriction, you have a pretty broad coverage of the uses that are and are not permitted in your community. So with that said, and specifically on short-term rentals, we have here the Eager decision, which was a 2-1 majority published opinion out of the Court of Appeals. And the majority said here that short-term rentals are a commercial use, even if the activity, such as people staying in a house, sleeping in the house, eating in the house for a few days, a week at a time, even though that activity might be considered residential, the short-term rentals themselves are a commercial use, and therefore any deed restrictions that bar commercial use would prohibit short-term rentals. I should note 2 things. One, the majority did leave the door open and say, short-term rentals might still be allowed even if you have a residential and commercial use restriction. If the use is pretty incidental, it's casual, doesn't happen a lot, it's not causing a nuisance to other people. So there might be a little bit of leeway there for short-term rentals. Or of course, if the owner rents the property for a longer term. So short-term rentals are normally many people consider those to be the 30 days or less category. And so the longer that the rental period is, the longer the rental period is, the less likely it's going to be considered a short-term rental. And of course, the other caveat is there's a dissent, which said basically what we discussed just a moment ago, the renter's activity in the property is residential in nature. And so this shouldn't be prohibited. That is the dissent. And so it should not be binding precedent, but a court may decide to move along with the dissent's rationale in reviewing this issue. So here we have a few different questions. First of all, some people wanted to know any monetary penalties and bylaws for short-term rentals. I have seen some associations adopt specific fines and penalties for short-term rentals, specifically to try to get at the potential income that might be coming from those short-term rentals to try to discourage them. However, just based off of our history of dealing with short-term rentals, many times the fines that you levy are probably not going to be enough of a deterrent. And what you really may need to do to get a short-term rental to stop is to file a lawsuit. Also questions on multi-use buildings with retail, would that negate the argument? Not necessarily. And so many times when you have properties that have mixed-use developments, you'll see restrictions on what you can do in the residential parts of the development and what can happen in the commercial side of the development. And so ideally there would be language there of, for the residential part of the development, residential use only, no commercial use there, and make that distinction. Somebody asked, what if it's been acceptable for 20 years? That's when you get into the waiver argument, which is also another very factually intensive analysis. But basically, it says under Michigan law that restriction can be waived if there's been a substantial change in the character of the neighborhood to the point to where the restriction is no longer a benefit to the community. And so in order to make that waiver, the person has to present a pretty strong showing. And so typically, the majority of the lots have been violating the restriction, or maybe it used to be a community in a residential area that's now been commercialized all around it. The commercial nature has started creeping into the community. So there is certainly an argument out there that if you've been allowing short-term rentals for a long time, and a lot of people have been doing it, that maybe that restriction has been waived. But at the same time, it is very factually intensive and does require a strong showing in order to be successful. And of course, too, if your documents have an anti-waiver provision, which basically says a failure to enforce does not mean that the association cannot later enforce down the road, that typically helps with those lack of enforcement problems. But as somebody just noted, this is why it's very important to adhere to your bylaws and enforce them when you know that a violation is going on. All right, so an issue that I've seen pop up more prevalently over the past year or so is lease compliance under the Michigan Condominium Act. So Larry lives in a lakeshore condominium, and his condominium bylaws require compliance with the Michigan Condominium Act and permit leasing without the association's prior approval. So he decides to lease this unit, and he executes a lease agreement with Tammy, which does not include any language about the condominium documents. Tammy moves in, but neither she nor Larry tell the association. And so the first question is, did Larry violate the condominium bylaws? Specifically by renting or leasing to Tammy without telling the association. And so as we see people, a pretty resounding yes. So that is correct. Under the Michigan Condominium Act, MCL 559.212, even if a co-owner does not need the association's prior approval to lease, the co-owner still needs to, at least 10 days before giving that lease agreement to the renter, needs to notify the association that they are intending to lease and to give the association a copy of the proposed lease agreement. And so Larry still needed to, at least 10 days ahead of time, let the association know, he was planning on renting to Tammy, give the association opportunity to look at the lease. And then there was an after the fact violation, which is that under MCL 559.212, once the lease agreement is executed and signed, that signed copy be provided to the association. So we have a before the lease is signed and after the lease is signed issue here. And does Larry's lease agreement itself violate the condominium bylaws? And so here we have a specific issue. And again, this goes under MCL 559.212, which says that lease agreements under the Condominium Act need to specifically tell their tenants and co-owners that they incorporate the condominium documents and that they're subject to the condominium documents. So here, we don't have any language in the lease agreement about the condominium documents. That doesn't mean that Tammy's not going to be bound by them. She's still going to be bound by them. But the Michigan Condominium Act does require that there be some reference to the condominium documents and the lease agreement. And so just briefly before we move on to the next issues, lots of associations are concerned about high numbers of rentals in the community and are looking for various ways to reduce them. And so one way that we recommend is through document amendments with various provisions that either immediately or over time reduce the number of rentals that are in communities. And so those document amendments typically look like a rental cap. So saying, no more than 20 or 30% of the units can be rented at any time, with hardship exceptions for co-owners who may need to, as a result of a job, leave the state for several months, or a co-owner who needs to go to a medical facility for several months, things of that sort. But that is one way to address those high number of rentals. Also, too, the limits on the number of units or lots that can be owned in the community. So that prevents a co-owner from buying up more than one unit or lot, and they can't necessarily live in 3 or 4 units at any given time. So it's pretty clear what they're going to do with the rest of those units and lots, and that helps control and make sure that you don't have rentals or a high number of rentals and leases in your community. Same thing too on limits on numbers of units and lots. One owner and the community can rent at any given time. So maybe co-owners can own multiple units, but they only get to rent one. And so again, if they start owning 3 or 4, they're not going to be encouraged to buy up more than that because they're not going to be able to rent them. And also too, corporate ownership restrictions. So addressing homeowners who may decide to buy a unit under a corporate entity, such as an LLC, and then, allow people to just come in the unit because the co-owner is the LLC. And so designating just whoever they want to come live in the unit at any time to kind of avoid those rental restrictions, and basically force them to commit to a certain individual who's going to be living, even though it's under owned by an LLC or another corporate entity. So we have a question here: when bylaws are updated, this does come into context with rentals and leasings to reflect new bylaw rules. Do existing homeowners prior to the updates claim grandfathered bylaws to neglect new bylaws? So grandfathering in current owners under new bylaws really kind of depends on the specific issue that we're dealing with. So under the Condo Act, when you do make a rental amendment provision, You cannot necessarily affect co-owners who are currently renting at that time. Can affect, their rental or lease agreements that may be in effect at the time of the amendment. And so many times you'll see associations grandfather in co-owners who are currently renting or leasing. And this commonly pops up too with smoking. If the community moves from a smoking to a no smoking community, you might see communities grandfather in co-owners who are already smoking. But otherwise, generally, co-owners are going to be bound by the new bylaws, even if it is a significant change where they didn't necessarily agree with the bylaw. So next up, marijuana and smoking. So we have here, Gary owns a unit in the High Times condominium. Recreational marijuana is legal in Michigan, and he smokes pot every day. And the bylaws drafted in the 1980s prohibit marijuana use and permit fines for violations. The manager sends Gary a letter fining him $25, stating he violated the provision prohibiting marijuana use, but he refuses to pay the fine because his conduct is now legal under state law. And so the question here is, does Michigan law supersede the bylaws? All right, so we have a little bit of a split here, but the answer is, in this instance, no, Michigan law is not going to supersede the bylaws. And so even though both recreational and medical marijuana are legal under state law, they remain illegal under federal law. And so the bylaws can still restrict marijuana use. And specifically to some of the Michigan law on medical and recreational marijuana use still notes that people can, or that private properties can still limit and restrict marijuana use over property they control. And so in this instance, the marijuana restriction is still gonna apply. And so is the $25 fine valid?
Yes, yes.
So a lot of yeses. Unfortunately, this one required close reading because he was sent a letter and fined $25 immediately, but he lives in a condominium. And when you live in a condominium, you can't levy a fine unless you give the co-owner a hearing and an opportunity to, present evidence of their defense. And so in this case, the fine likely is not going to be valid. And ideally, what should happen ahead of time is that a notice of violation should be sent to the co-owner saying, this is what you did. These are the provisions that you violated. We intend to levy fines. Here is your opportunity. Here's the next board meeting where we're going to discuss this violation. You're invited to attend, offer a defense if you wish. And, at that time, we'll decide whether or not, to confirm the violation and to levy a fine. And so just an important reminder for the condos, especially to make sure that you at least provide for that first notice of violation an opportunity for a hearing before the fines actually start getting assessed. A question was, can an HOA fine without a hearing? That will depend on your documents. So homeowners associations, subdivisions, are not under the Michigan Condominium Act. So instead, you will need to look at the language in your documents and see if a hearing is required. It's a good question, distinction between the subdivisions and the condos. So now, medical marijuana. We have here the Leafy Greens Condominium Association. Smokey has requested, he has a medical marijuana card. He's requesting a reasonable accommodation under the Fair Housing Act so he can smoke marijuana in his unit. And he has a note from his doctor that states that marijuana will help ease his anxiety. And so the question is, does the board have to grant his request? See if any thoughts roll in. So I gave you a little hint just a few minutes earlier. The answer here is no, because, yes, there we go. Because it's based off federal law. It remains illegal under federal law. And in 2019, there was a landlord-tenant case specifically regarding this issue. A tenant who wanted a reasonable accommodation to use medical marijuana and had been refused to. And the court said, listen, you don't have to grant an accommodation to allow somebody to engage in illegal activity. So even though there is a recognition, maybe this is permissible under state law, it is still under illegal under federal law. And so as a result, you, the landlord, do not have to grant that request. Somebody asked, what is the name of the 2019 case? I do not know it off the top of my head, unfortunately. But it's possible we might have it cited in one of our blog articles. So I might take a look at some of our medical and recreational marijuana articles online. I would hope somebody has cited it there. All right, and somebody asked earlier about what about growing? Well, that is an area of issues that I have seen growing in my own practice of co-owners who are growing or homeowners who are growing marijuana in their units. So in this case, Chuck cannot handle his job. So he resigns, starts a recreational marijuana business out of his unit. The condo bylaws prohibit illegal and commercial activity, but recreational marijuana, including some growing, is legal. So he sets up some grow lights in his basement, begins growing marijuana to sell to others. And to increase his profits, he plugs into the electrical outlet outside of his unit, and the association's electric bill increases $5,000 the following month. And the question here is, can Chuck grow marijuana? A very quick no. And so based off of all our conversations we just had, again, we have an issue of it remains illegal under federal law. And so it does still violate the illegal activity provision. But here, does the association have another basis aside from marijuana to pursue a bylaw violation? So aside from the fact that marijuana is illegal under federal law, let's see, Kathy got it. Operating a business out of his unit. So there are prohibitions against commercial activity. And here we have Chuck is using it to operate a business. He's going to be selling marijuana to others. Ideally, or not necessarily ideally, but to help the facts of this situation and to help enforcement, he may have customers coming to his unit or his house to pick up the marijuana, things of that sort. And so that would be another potential basis there to pursue Chuck, is the commercial activity that he's engaging in. Somebody else also said two potential safety issues. So, you know, there are many times in condominiums provisions that prohibit unsafe activities or things that could harm or damage the common elements. And so there might be a basis here too, based off the lights that he is using and how his operations are going, that maybe there's a potential safety issue here as well. And last question on this, can the association recover the $5,000 from Chuck for all of his electricity usage?
Yes.
All right, so a lot of people say yes. It is possible. It is not a guaranteed yes. And so it will depend on Chuck's particular condominium documents. And so typically the language that you will need to look for is, in order to be able to assess Chuck the $5,000 and hold him responsible for it, typically you will want to look for what we call waste provision. So something that specifically says, hey, if somebody uses one of our shared utilities and, you know, greatly exceeds the reasonable usage of it, we can assess that co-owner back for their use. Other times you will have language within your documents that says any expenses incurred as a result of one person's conduct can be assessed back to that particular unit and co-owner. And so that would be another potential basis for assessing that back to Chuck. So if that is something that association is going to assess some extraordinary costs that they've incurred from a co-owner, just make sure to look through your documents and make sure that there's something that specifically gives you that right to assess those costs back to that particular co-owner. All right, last but not least, smoking. So Sandy's been smoking her entire life. She lives in an attached condo. April suffers from asthma. She's our neighbor, and she wants the association to prohibit Sandy and everyone else from smoking in the condo. And the bylaws are silent on smoking, but the board sees that they have authority to pass rules and regulations regarding activities within the condo. So they pass a rule that bans smoking, and they file a lawsuit to force Sandy to stop smoking. And so the question here is Sandy going to be forced to stop smoking? All right, some pretty quick no's, and I would agree with that. That goes all the way back to our first slide, our first issue, talking about passing restrictions via rules and regulations instead of your bylaws. So in this case, because the bylaws are silent on smoking, this would have been presumed to have been a smoking permissible condominium. And so in this case, if the association wanted to move from permitting smoking in the condominium to prohibiting smoking in the condominium, they would need to do so via an amendment to their bylaws, not through rules and regulations. So unfortunately, in that regard, Sandy's probably not going to be forced to stop smoking based off of the rules and regulations. However, what are some other options the association would have to try to address this particular issue? Does anyone have any thoughts? Somebody asked if they did pass an amendment, would she then be grandfathered in due to living there prior to the change? So the Condominium Act does not necessarily speak to this, but typically what we see is condominiums who move from a smoking permissible to a smoking prohibited community will grandfather in their current smokers, just because otherwise you make it extraordinarily difficult for them to live in the condominium. And if you're a condominium, you're going to need 2/3 co-owner approval. And if you have a good number of smokers, if you don't grandfather them in, they're probably not going to vote on that amendment. And so just typically it's standard practice, we tend to see smokers grandfathered in. So some people mentioned that you could pursue possibly violations based off of obnoxious odor, nuisances, things of that sort. That's certainly true. So of course, one potential option they have is they could try for the bylaw amendment and see if they can actually get 2/3 of their co-owners to go for it. Maybe they'll have to grandfather Sandy in, but that's one option. Another option that attached condos might want to pursue is seeing if they can have air filters installed in smoking units to really try to limit the odors that are flowing between units. And we're just going to briefly touch on parking and towing, specifically for our condominiums and subdivisions who have limited parking and really have to control, monitor where people are parking and who's parking there. So we have the Limited Space Association. They are assigned parking spaces under the docks, and there are very limited spots for other parking. And the governing documents say that towing is permitted, but the association does not have a sign regarding towing of vehicles. So a guest, unfortunately, there again, parks in a reserved spot, and the association's furious and orders a towing company to remove the vehicle. And so does the association in this instance have the right to tow Gary's car?
No.
All right, pretty quick no. Another no in the chat box. Yep, somebody has paid attention to the Michigan Vehicle Code on this one. So in this instance, the association is not going to have the right at that particular time to tow his car. So there's two provisions under the Michigan Vehicle Code that come into play. The first is the signage component. And so if you want to tow vehicles from a private property, you either need to have a notice, a sign that is pointed at entry points where vehicles, in order to get into your community, they're going to have to pass it, they're going to see it, and it has to clearly say in specific measurements that vehicles can be towed away at their expense. Here's where it's going to be towed to, here's the number, and you know, it has to be there for a certain amount of time. So that is one option. The other option under the Michigan Vehicle Code is when notice is personally given to that person that they parked somewhere that they shouldn't be and they need to move the vehicle, otherwise it's going to be towed. So just make sure, you know, even if your documents say, hey, if you're parked where you're not supposed to be parked, you know, we have a right to tow and we're going to tow. Just make sure that you either have some notice, if depending on the makeup of your community, if you have some way to put notices at your entry points about that towing, or if not, that you have some way to give notice to those co-owners, their guests, or visitors that they're not there, or that they're not parked where they should be and that they're subject to towing. So someone said, if we tag a vehicle, is this damage to private property? So typically what I see people do is, you know, if you, instead of necessarily tagging the vehicle, possibly doing, you know, a piece of paper that goes under the windshield wiper, so there's not some argument there about tagging. Or a lot of times, if you have controlled entry points, people will just post the notice signs. And so that's an argument that you don't even have to get into and deal with. All right, so briefly going to touch on hoarding, especially as many of our communities get older. This is becoming a more frequent thing. And so we have here that Harriet lives in the Clean Living condominium. They've become aware that her unit is stacked with garbage and newspapers from floor to ceiling, but she does have a clear path from the front door to the back door. And so the question here is, has she violated the bylaws?
No.
We have some people saying no, we have some people saying yes. Typically within the condominium bylaws, we'll have provisions regarding the fact that co-owners have to maintain their units in safe, clean, sanitary conditions. And while she has a clear path from her front door to the back door, I'm not a fire marshal, but I anticipate if the fire department came in, they would probably constitute her unit as a fire hazard, safety hazard. And so she likely is not maintaining her unit in a safe condition. And if there is language regarding that, she's likely violated the bylaws. And typically in the condominium documents too, there's language about maintaining limited common elements that are pertinent to the unit in safe, clean, and sanitary conditions as well. So does it matter here if Harriet has a mental health disorder?
No.
So for purposes of, you know, are you going to have to give her some sort of reasonable accommodation? Again, if you go back to the Fair Housing Act analysis of you don't have to permit activity that could pose a direct harm or threaten the safety of others. You know, the fact that she has a mental health disorder is probably not going to allow her to have a reasonable accommodation to keep an unsafe unit. However, in terms of dealing with Harriet, it is going to come into play, and it is something that the association could consider, is that, you know, this person does have a mental health disorder and the hoarding is likely a result of that. And so while you may not have to grant an accommodation for that and resolving the issue, that is something that you're going to have to deal with. and confronts. And so what are some resources that co-owners could use, or homeowners associations in general could use to try to help address the situation? So somebody mentioned family. So if you can get family on board, if you can find them, if you can contact them, if you can get them involved, certainly they can be a resource to help. Many times in these situations, the families have dealt with it for so long and have tried to remedy it for so long, and they've been unsuccessful that they may not be helpful, but still reaching out to the family to see if somebody's on board and can help is a resource. Other possible resources too would include, if you can get the fire department out, the health department out to provide some sort of inspection and let you know, like, is this a safe condition of the unit? What needs to be done to get it fixed? That can be helpful. For older adults, adult protective services might be something that's helpful as well. If you have an instance of a homeowner who is hoarding a lot of animals, animal control might be a good resource to reach out to try to help the situation. And along with adult protective services, many counties have kind of services for the elderly programs and stuff like that, in terms of, helping people keep up with their errands or household chores and stuff like that. So using your local and county departments, both health, fire, and for the elderly, can be helpful in trying to address those situations and at least getting some additional resources into the unit to try to resolve it. So unauthorized modifications, alterations, probably one of the most frequent bylaw violations are Community C. And I'm sure you have heard this one over here about it being a free country many times. In defense of these modifications and alterations. So first one up, get my slide, there we go. Fran thinks her backyard is a little lackluster, decides to spice things up a bit. So she finds a 9-foot tall, beautiful fountain, and she submits an alteration modification request to her architectural control committee. And the restrictions say if the committee doesn't act within 30 days, she can request the board of directors to consider her request. And if they don't act within 30 days, then her request is considered approved. She does not hear from either the committee or the board. So on the 61st day, she installs her 9-foot fountain. And does Fran get to keep her fountain?
No.
All right, we have a quick no. Somebody says yes. All right, so this was another trick question of mine that goes back to my case law update that I gave in January, a few months ago. Facts just like this. And the trick is in the language that says that if the committee does not act within 30 days, she can request the board of directors to consider her request. And then if the board of directors does not act within 30 days, her request is considered approved. In this case, Fran did not request the board of directors to consider her request. So her request is still considered not approved. And so she is not going to be able to keep her fountain. And so a few important lessons for both co-owners, homeowners, associations, everyone involved. Make sure that you carefully follow your approval process, and to the extent possible, don't let alteration and modification requests sit out there for a long period of time. And from a homeowner situation, it's really kind of a homeowner beware, because little tricks like asking that it request that it go up to a higher level, if the homeowner doesn't follow those, their request may be deemed denied or not approved, and going to result in some substantial financial losses in having to remove that fountain. And just as another resource, just this past week or so, we posted a blog article on homeowners, and is it better to ask for forgiveness than to ask for permission? And in line with that, I would suggest that you read that. And as you can imagine, the answer is better to ask for permission, not for forgiveness. Sorry to spoil the end for you on that one. All right, so another one with a slight twist. Bob's in a wheelchair. He needs a wheelchair ramp to enter his unit, but the bylaws don't permit modifications to the common elements, which includes the pathway to his front door without board approval. So he submits a plan for a ramp that has 25 lights on it that shine into other units. The board meets quarterly, but does not meet for another 3 months to consider the request. So he builds the ramp anyway. And they send him a letter demanding that he remove the unapproved ramp and lighting, and he refuses to do so. And so the association sues. So for the first question, does Bob get to keep his ramp? Got some pretty quick responses there. So we had here some answers, pretty quick responses of no. So actually Bob is going to get to keep his ramp because he lives in a condominium, and under the Michigan Condominium Act, it's at MCL 559.147A. Co-owners are allowed to make modifications to the common elements for purposes of being able to enter their unit, or in terms of interior modifications for being able to kind of maneuver around their unit or access their unit from the interior. They're allowed to make modifications to the common elements for those purposes. And if there is no response to their request within 60 days, it is deemed approved. So again, that's specific for the Michigan Condominium Act language. For homeowners associations, the applicable time period comes under the Fair Housing Act, and that just says a reasonable time. So it's a little bit more loosey-goosey. It's not going to give you an exact time frame. However, in this case, if Bob is in a wheelchair and he needs a wheelchair ramp to enter his unit, I'm going to say a reasonable time is going to be sooner rather than later, because otherwise there seems to be a question of whether Bob's going to be able to enter his unit or not. So the moral of this story is, when you get these requests, if you're a condominium and it's a modification request based off a handicap or disability, make sure you respond to it within 60 days. If you're a homeowners association, you're under the Fair Housing Act, so you're operating under a reasonable time, but that also does not necessarily mean you get to set and hold on to the request for an extended period of time. Now, for his lighting, does he get to keep his lighting? Some people are like, what about lighting? Well, don't worry, I've got you here. So some people say, the lights should probably go. He's probably not going to be able to keep his lighting. So that one I think falls a little bit more kind of in the middle ground. When it's dark outside, he's probably going to need some lighting to kind of see where the ramp is and to make sure he can maneuver safely on the ramp. So I think that some lighting here is going to be appropriate for those purposes, but certainly the lighting that he has would need to be either reduced or moved so that it doesn't shine into the other unit. So I don't think that this is a hard, all the lights are going to go, but I do think that the lighting is going to have to be addressed in terms of making sure it's not shining into other units and it's not causing a nuisance. And last one on this one, the association would prefer that he install the ramp at his back door so the ramp is not visible. Can the association require him to do so? So we have here a yes. So this one is a little bit more tricky too. However, Fair Housing Act and HUD, somebody said maybe. I think that's a good, just play it safe in the middle. The association's probably not going to be able to require him to install the ramp at the back door unless there's some safety or other concerns, such as maybe the ramp to the front door can be installed in such a way that it's not going to prohibit other people from being able to use the area and access their own units. So at that point, they might be able to require him to install it at another location. However, if it's just a preference, if the ramp itself is not going to be a safety issue, other people are still going to be able to move around and access it, and it's purely just an association preference, the association is not going to be able to require him to install it at the back door. And the rationale for that is if other co-owners and homeowners get to enter their unit from the front door, why doesn't this homeowner and co-owner get to enter through their front door as well? So again, if you have a specific safety reason, you might be able to require a different location, but if it's purely an aesthetic reason, that's probably not going to fly. All right, so wrapping up, and then I know I've been trying to answer as many questions as I see in the chats as possible, but I know that I have missed a few, so I'll make sure I stick around for those questions at the end. So here, Mary buys a condo in 2013. The bylaws do not permit any modifications to the exterior of the unit, including the decks, without approval from the association. Prior owner extends the length of the deck, paints it a different color before the unit's sold without the association's approval. But the association does not discover the violations until 2015, but they file a lawsuit against this new owner seeking an injunction to require Mary to remedy these issues. And so, is Mary going to be responsible for the violations of her prior owner?
Yes.
Ooh, big, quick, strong yes. That is correct. So this is a case up at the Michigan Court of Appeals, unpublished case, but still published authority that said violation is a violation. It's ongoing. And so even though this particular co-owner didn't cause a violation, it's her unit, she's going to be responsible for remedying the violation. And here they waited about 2 years before they noticed it, before they took any action. Has the association waived its right to enforce the bylaws by waiting this long to take action?
No.
All right. We have some answers. No. Somebody asked the case law for this. So this is Fox Point Association versus Ryal, R-Y-A-L. They don't have the specific case numbers, but that's the name of the case. In this case, the Court of Appeals said no, they had not waived its right to enforce the bylaws. And they specifically relied on the fact that their documents included an anti-waiver provision. So again, language that said a failure to enforce does not mean, at one point in time, does not mean a failure to, or you can't enforce later on down the road. And so the association got to hold her responsible for that. All right, security cameras, Ring doorbells. I'm sure lots of people are dealing with Ring doorbells in their communities. So we have here Stuart, who lives in high crime condominium. There's been an increase in break-ins in the condo. He suspects one of his neighbors may be the culprit. So he installs a security camera without submitting an alteration request. And he positions it in such a manner that he can see inside his neighbor's screened-in back porch, where he believes he's fleeing after his crimes. His neighbor notices the security camera and submits a complaint to the association. Did Stewart violate the condominium bylaws?
Yes.
So yes, the answer here is going to be very likely yes. It's a condominium, so there's very likely going to be no alterations or modifications to the exterior appearance without association approval. And if it's an attached condominium, he probably installed it on a common element. And there's probably also too language that says you can't make an alteration or modification to common elements without board approval. So Stewart likely violated the condominium bylaws by installing this. Next question on this one. Did Stewart violate his neighbor's right to privacy? See what we have. So a lot of people said yes. I think that this is a close one, but I think that this would probably lean a little bit closer to the yes side of things. And so, people really have a right to privacy in terms of this situation, right to privacy for things that, you wouldn't ordinarily be able to see. And so, if you're out in your front yard, doing something out in your front yard where anybody who's walking by can see you, you certainly have a limited right to privacy in that instance. However, here the facts say there's a screened in back porch. And so, you're getting a little bit more into the unit, you're getting into a little bit more of an area where a person would expect to have a higher right to privacy. And so with the camera pointing directly to where Stuart can see inside that, I think his neighbor is going to have a pretty good case that his right to privacy has been violated in that instance. Last but not least, and then we'll move to a quick wrap up and some questions. So we have here documents that prohibit homeowners from placing any signs, garden flags, lawn ornaments in their front yards without the association's approval. Rachel places a political sign in her front yard. She doesn't submit a request to the association, so they send her a violation notice, threaten to levy a fine. Notice, threaten to levy a fine. They have not issued the fine yet if she doesn't remove it. She walks through the neighborhood though, and she notices lots of other people with non-political signs, garden flags, lawn ornaments in their front yards. And those people also did not get the association's approval. So she refuses to remove her political sign. Can the association begin assessing fines against Rachel's unit?
Yes.
So we have here answers of yes. And I would say the answer here is going to be a yes if they also start issuing notices to everybody else who does not have approval. And so, as I'm sure many of you are familiar with, when you send a bylaw violation notice to a co-owner or a homeowner, many times a defense is you are selectively targeting me, you are selectively enforcing bylaws against me. Look at all these other people who have violated the documents. In this instance, Rachel's argument to that extent would certainly be warranted, since many other people also apparently too are in violation, and those violations have not been sent. So if there is a rampant problem in your association, or rampant violation, make sure if you're going to send a notice of violation, you send them to everybody. And you don't necessarily just pick one or two people to single out for that violation. And a hard question to end the night: what about Rachel's First Amendment rights here? Somebody asked, political signs within 15 days of public elections. How do you deal with that? So somebody noted, it's still a bylaw violation, and that's certainly true. And so generally the position is that community associations are not governments, are not state actors. And so therefore, you don't necessarily have to protect your co-owners or homeowners' First Amendment rights to political speech or other speech within the community. And so if you want to restrict all signs, that's certainly something that you can do, even though a co-owner or a homeowner might say that the sign is, protected speech. So typically, those First Amendment rights in this context are not going to apply to community associations. Okay, so quick wrap up here, and then we'll move to any burning questions on enforcement options. So we've talked fines. That is one potential enforcement option. Hopefully that is something that will work depending on the degree and severity of violation. A fine may not be appropriate, like I mentioned earlier, for short-term rentals and things of that sort. But especially for the condominiums, remember, if you're going to fine with that first notice, make sure you give a hearing before you levy that fine. And then, of course, if you have homeowners and co-owners who are not paying their dues and not paying their fines, You may have the ability to record liens for non-payment of those items and possibly pursue foreclosure or money judgment remedies, depending on what your or homeowners or condominium documents might say. Depending on the violation, you might be able to also receive some money damages. However, most of the time, the most appropriate relief for associations is going to be injunctive relief or a lawsuit, which simply tells a co-owner, a homeowner, you have to do this or you can't continue doing this. So money damages could be an option, but what's probably going to be more appropriate is injunctive relief. And then, of course, too, depending on what your documents say, you might be able to recover your attorney fees and costs in getting their compliance. And so one thing that we really recommend our associations have is the ability to collect pre-litigation attorney fees and costs. So costs that you may incur in investigating the bylaw violation, and just those communications that happen with a homeowner and co-owner to get their compliance before a lawsuit is even filed. Other associations may just have a recovery of attorney fees and costs in litigation. So once you file the lawsuit, so if there's been a lot of back and forth up to the point of the lawsuit, you may not be able to collect those, which is why it's really important to have a pre-litigation attorney fee and cost provision. And of course, like I mentioned earlier, there might be language within your documents that allows you to collect unusual expenses, expenses related to co-owner conduct. That could be another way that the association tries to recover some expenses they normally would not have occurred, or attorney fees and costs in handling homeowner and co-owner compliance issues. And as I just ended with, bylaw enforcement policies, those can be very helpful in making sure that associations, property managers, and boards really consistently enforce the bylaws to make sure that when you do send out those notice of violations, you don't have an issue where co-owners and homeowners are coming back noting that there's all these other violations too that you're not addressing, and you're selectively enforcing or targeting the restrictions against me. So with all that said, I will go ahead and open it up for some questions. Before I do though, I will note that this section here is just going to be a general advice section. And so if you have a specific question to your specific association, I would just ask that we talk offline about that, either with myself or another attorney here at the office. But if you have some general questions about bylaw violations and how they handle them, I'm happy to answer them.